Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, everybody. Please be seated. Welcome to the United States Court of Appeals for the Fourth Circuit. We have three cases on for hearing this morning. First is 24-6490 Steen versus the Smukes. Ms. McNeil.
Thank you, Your Honor. May it please the court, my name is Mary McNeil, and I represent petitioner appellant George Steen. Before I start my argument, I would like to clarify something in the state's brief, something that I did not address in my reply brief. On page 39 of the state's brief, the third paragraph, the last paragraph, third sentence in, it begins with, the record evidence established that, and then it has a list of things. About the third one down is that another child in MS's biological family's household had been sexually abused by MS's father prior to being placed with the Steens. And I'd just like to clarify that the jury never heard that information. That was testified to. It's on the record. It's in the transcript. It was on voir dire that a case manager testified to that information, but the jury never heard it. And this case is about what the jury didn't hear. The jury didn't hear pivotal information because trial counsel did not do a reasonable investigation of his client's case. As you know, Strickland v. Washington has two prongs. The first is an unreasonable error by the trial attorney. And the second is there is a reasonable probability that but for that error, the outcome of the trial would have been different.
Can I ask you, which of the decisions below do you think we should be considering in deciding this issue? Because there seems to be some confusion that the state trial court, in a very short opinion, suggested that perhaps both prongs hadn't been satisfied. Then the federal district court, then the Court of Appeals assumed deficiency and focused solely on prejudice. And then the district court seems to have ignored that decision and just focused on deficiency. So which decision are we supposed to focus on?
I would look at both of them. They're both state.
Both of what? The state?
I'm sorry, both the MAR court's decision and the Court of Appeals decision.
Both, haven't we and the Supreme Court both said that's not true? That the only decision for AEDPA deference purposes that matters is the last state court decision, and the last state court decision here is the North Carolina Court of Appeals decision.
Yes, Your Honor.
Well, no, but this seems pretty important because, as the Chief said, the trial court said no prong 1 violation and no prong 2 violation. But the state appellate court said we are not going to decide whether there was a prong 1 violation. We're just going to rule against your client on the grounds that he fails at prong 2, which is a pretty important distinction because if that's the decision we're reviewing, there is no AEDPA deference on prong 1. So which do you think it is?
I think it is the Court of Appeals decision, the prejudice prong.
So what do you think then we should do given the fact that the district court's decision grants AEDPA deference on prong 1? That's the basis of the district court's decision.
Yes, well, the district court's decision is reviewed de novo. So you look at prejudice and you look at the Court of Appeals opinion and the prejudice, the decision made on prejudice.
So you're comfortable doing that, and that makes sense. I mean, you look through the district court's decision and look at the last decision at the state court level. The concern that we might have, though, is we don't have the benefit of the district court's reasoning as to prejudice. Do you see any concern with that?
No, I do not, because I think, again, you're reviewing it de novo, and so I think you can make your own determination.
Okay. So if that's your view, do we need to spend any time on deficiency, or can we just simply focus on prejudice?
We can, well, I would like to address both.
I know you would. And that's fine. I mean, it's your time, but if in the end, we assume deficiency and move straight on to prejudice, that seems to be the really important question, but again, it's your time. You
No,
decide how you
yes,
want
Your
to-
Honor, I agree, and I actually would like to start with the prejudice prong
All right.
of Strickland. There are two crucial facts in the DSS records and the counselor's notes. One is that the oldest sister engaged in anal sex with MS when MS was around 4 and still in the biological home. The second is that while MS was testifying, he was under a person-centered plan. And one of his goals was not to lie about his sexual behaviors 4 out of 7 days a week. The exact language is, he is to accept responsibility for his sexual behaviors as evidenced by not lying, being manipulative, or rationalizing his actions 4 out of 7 days. There are several reasons why the incident with the sister is very important and not cumulative. One, it provides an alternate source of sexual knowledge, specifically anal sex, that occurred before MS lived with the Steens. Second, it shows that MS has a motive to lie. He blames Mr. Steen because he wants to be reunited with his biological family. And it also could have been used to impeach MS's credibility. He said that it was Mr. Steen who taught him these behaviors, and that Mr. Steen was the first one to do this to him. So that information is important.
Okay. So let me just stop you there, and you may have some others, but, and I want to make sure you focus on what exactly our role here is that it may very well be that if we had been the decision maker in the first instance, perhaps a trial judge or a court of appeals, looking at the question of prejudice, might well agree with you that it seems like there's some kind of a smoking gun here. But of course, we're on EPA review, which means that not only do you have to show evidence of prejudice, but you also have to convince us that no reasonable decision maker, no fair-minded jurist could have come to a decision that the Court of Appeals came to with respect to prejudice. And to its credit, the Court of Appeals issued a reasoned opinion. They went through some of the evidence, maybe not all of it, and considered in the end that most of this information that you're now focusing on would have been cumulative to that which was presented to the trier of fact. And so how do you persuade us that no fair-minded jurist could have gotten that, could have arrived at that result?
Well, first of all the evidence of alternative sources for MS's knowledge occurred after he had been with the Steens. The jury did not hear about an alternative source from before MS lived with the Steens.
And can you help me to understand why that matters? Let me just walk through the reason I'm inclined to think that it doesn't, but I want to give you a chance to tell me why it does. So as I understand the defense's argument in this case is, well, one, Mr. Steen did not do, argument one, Mr. Steen did not do this. So two, when this individual says that Mr. Steen did this, that individual is not telling the truth. And part of the state's argument is, well, but one of the ways that you know he's telling the truth is that he's talking about things that he wouldn't know about unless something like this had happened to him. So the fact that he's talking about it is indirect evidence that he's telling the truth. And your response is, well, that only assumes that he couldn't have learned about it some way else, because that could explain how he would know about things he wouldn't otherwise know. So for those purposes, it doesn't seem to matter if the incident the jury heard about is before or after he lives in the Steens. What matters is, did this happen to the victim before he accused Mr. Steen? Because you need an like the whole premise is, I mean, the defense's argument, although they have to dance around, the premise is that this young man is lying or mistaken about what Mr. Steen did to him, and the explanation is, well, how could he possibly have learned about this? And it's like, well, it turns out that after he lived with the Steens, but before he accused Mr. Steen, something like this happened to him, which could explain how he. So could you just help me understand, why does it matter if the incident happened after he lived with the Steens, if the reason the evidence would be offered is to explain an alternative source of the information contained in the accusation that the young man makes to the authorities?
Well, the state makes a strong argument talking about the incident with the two boys.
Right. And the MAR court relies on the incident involving the two boys as well. I'm looking at a quote from their opinion. They also say the jury heard about the incident involving the two boys. That's an alternative explanation.
The state presented that, was very clear to present that as something that happened after he was with Mr. Steen.
I understand that temporally, but I don't understand how that matters for the defense's theory. So in some ways, if the prosecutor would say, members of the jury, you know Mr. Steen is guilty because this child knew about something he shouldn't have known about, and the defense attorney can say, what are you talking about? The jury also heard about this incident involving the two boys, which could also be the source of the information, right? I don't understand why the timing of when he lives with the Steens doesn't seem to me to matter for the defense argument. What matters is this incident happened before the victim accused Mr. Steen.
Well, it's also important because it provides a reason for MS to lie about who did this to him. He was lying to protect his sister. It's also important because this is a credibility contest and it goes to MS's credibility. He is asked, who taught you this? And he says, Mr. Steen.
Right.
It's repeated several times in the video that is shown to the jury. He blames Mr. Steen. And it's important for the jury in assessing his credibility to know that MS is under oath and is lying. And it's also valuable for the jury to know he has a reason for lying about who did this to him. He's not mistaken. He is trying to protect someone, but the person he's trying to protect is his older sister because he wants to reunify with the family. So it's very important as to credibility, as is the person-centered plan that he was under when he was testifying. That's also very important and something that the jury did not know about. And it could have been used to impeach MS. It could have been used to impeach the counselor and the case manager who says he doesn't lie any more than the average child. He clearly has a problem with lying. And so those pieces are crucial to the case, and it's something that the jury did not hear.
All right, Ms. McNeil, you've got some time for rebuttal, so thank you.
Thank you.
Ms. Lawrence?
May it please the court. I am Sherry Lawrence with the North Carolina Department of Justice, and I represent respondents Leslie Cooley-Dismukes and Brett Bullis. The question before this court, as your honors has mentioned, is whether the state court's application of the ineffective assistance of counsel standard under Strickland was unreasonable. The doubly deferential standard under EDPA and Strickland's deferential review of counsel's judgment applies in this case.
Wait, but can you agree we don't actually apply double? So I've always understood doubly deferential as applying to Strickland prong 1. And do you agree that there is no EDPA, that notwithstanding what the district court said, there is no EDPA deference at Strickland prong 1 because the North Carolina Court of Appeals made no finding about Strickland prong 1?
As to prong 1, yes, that is correct, your honor.
I've always understood doubly deferential to refer to Strickland prong 1 because the whole idea is that under Strickland prong 1, we don't like quarterback what lawyers do after the fact. Even under Strickland, plain vanilla Strickland, we give a lot of deference to lawyers' tactical choices. Correct. And then when we add EDPA, we have to give even more deference to their tactical choices. I'm not sure that we say doubly deferential at the prejudice prong because the prejudice prong isn't about deference to counsel at all, is it?
I think I've always looked at it as both prongs,
Okay.
EDPA applying to both prong 1 and prong 2. Here, the Court of Appeals of
Does it
North-
matter, just to follow up on Judge Heighten's question, the court seems to refer to doubly deferential as deference to the lawyer and deference to the judge, the state court judge. When we look at prejudice, does it matter that it's like a predictive judgment? Right, so, you know, what prejudice is like, if you had other information, would the jury have done something different, right? And so
Right.
you've got a state court judge making a predictive judgment. It's not really a legal judgment in some sense. Do you think that affects the deference that we give to the state court?
I would say no, because the state court is in a position to analyze, of course, the facts before the case, and applies the prejudice prong as long as the state court does a correct application of that analysis of prejudice under Strickland.
Can I ask you, there's this flavor in your, I'm just trying to understand this sort of, this is a question about prejudice. You make a variety of arguments in your brief, but the one I want to ask you and where it seems most troubling to me that we don't have any decision from the district court. How much does your argument depend on a prediction of whether the proffered evidence would have been admissible under the North Carolina rules of evidence? I know that's a flavor of your brief, but how important do you view that as important to your prejudice argument, the claim this evidence would have been inadmissible?
Your Honor, I think that's more important to the prong 1 deficiency, because it
It's
would
not
go-
unreasonable to not try to introduce evidence you probably couldn't have gotten in?
Yes, Your Honor, goes to that trial counsel's thought process and trial strategy in making his decision.
Okay, but let's assume we're at Strickland prejudice too. How important is it to your argument in Strickland prejudice that the prediction that this evidence would have been inadmissible?
I think the prediction that it would have been inadmissible as to prong 2, not extremely important, because at that prong, you were looking at all of the other evidence that was presented, and under Strickland prong 2, as your honors know, is a prejudice analysis, and you're showing with all of this other evidence, had he done what he's supposed to, the jury still would have reached the same result. It would not have been a different result. And here, there was other evidence in the trial. There were at least one piece of evidence that was fatal to defendant's case and to defendant's claim as well. Defendant admitted during the jury trial that he showered with this child. My friend of the court argues that this sexual knowledge was very important. Defendant himself testified during the trial that 4-year-old MS came to his house, and he came to his house in foster placement initially directly from his biological mother's home, and he exhibited sexual behaviors within 6 days of that placement. Within 6 days of that placement, he pulled his underwear and his pants down and told defendant to suck it. In addition, he observed MS humping a pillow, and when inquiring about what he was doing, MS told him he was having sex and that he observed that from his parents. That shower admission is very important, taking into account this initial sexual behavior that was exhibited within six days, because petitioner was a foster parent. He was a foster parent, saw this behavior within 6 days. However, admittedly still thought it was a great decision to shower with this young boy who was 4 years old.
And so is your argument that once the jury hears that he did that, they're going to find him guilty? I'm just trying to make sure I understand why this argument is relevant.
It is relevant, yes, exactly for that point. And that's only one piece of the puzzle, and I think that is a very important piece that's fatal to the defendant's claim here, as well as to his determination of guilt at trial. So he admitted that. In addition, there was testimony also from Mr. Letford that he was the foster parent that took over some years later, and the foster parent whose home MS was residing in when he actually reported to the wife or to the mother, foster mother, that petitioner had sexually abused him. So he asked Mr. Letford, his foster dad at the time, hey, can you take a shower with me, and requested the same thing. Mr. Letford had a more reasonable response, and he said no. He explained to him why that was inappropriate and why they weren't going to do that. So I think that's also very important because it forecasts a reasonable response from another foster parent.
Can I ask you?
I don't disagree with you that that's difficult evidence for Ms. McNeil, but there really isn't any other direct forensic evidence, right, of abuse that the state presented at trial. Is that fair?
Your Honor, that is correct. There was no physical evidence and there was no forensic testing that was done to confirm it.
So essentially, as your colleague on the other side says, this really boils down to a credibility fight, right? Who's telling the truth? And it would seem to me that the more evidence suggesting that one party or the other is not telling the truth, that has significant potential to alter the jury's verdict.
It does. However, here, in addition to all those things that I noted, what's also most important is the other evidence. We have testimony from MS. He consistently testified about these acts, that petitioner sexually abused him by sticking his penis in his...
Well, I mean, Ms. McNeil would say that he's just consistently lying about it.
Yeah. And I think that goes also to what else the jury heard. There's no motive that was shown in this record for him to lie about this. And I think petitioner does state that...
Ms. McNeil just offered one. The motive to lie is to protect his sister.
Correct. And I think in the brief, it was the motive to lie to protect his sister because he wanted to be reunified with his mother.
I mean, as motives go, it's not the most implausible motive I've ever heard.
However, sitting in the jury's shoes, he lodged these accusations 2 years after. 2 years after being removed from the Steen's household. He was with the Letfords. So waiting this almost 2 years to report did not benefit him at all. It didn't benefit him for being reunified with his mother or accusing his sister. The more reasonable, I think, thing would have been to accuse who he was living with at the time, which was Mr. Letford, if that was the case, because he was not in the Steen's household at that point.
So can I ask you about the part of the MAR court's reasoning that again, whether this gets over AEDPA prejudice is a different question, I know, but let me just tell you what I find to be the most problematic aspect of the MAR court's reasoning, is that at points they say, well, this isn't that bad because the jury heard other evidence, which I think makes sense as a theory, right? Like, so let me just spot that I think you have a very good case on the lying, the tendency of the victim to lie, because as the MAR court says, and I found it very persuasive, like the jury heard tons of evidence about the victim lying. Person after person after person talked about the victim lying. The idea that if the jury heard even more evidence about the victim lying, they would just be like, we've been repeatedly told that this young man lied on numerous occasions. So that part I'm not troubled by. But here's the other part. They sometimes say like, well, we don't need this other evidence because Mr. Steen testified to these other things as well. And that part seems, again, whether it's AEDPA deference is a different question, but that strikes me as deeply problematic for the following reason, which is if the only source that a jury hears something from is the criminal defendant, it seems very plausible the jury might say, well, that's extraordinarily convenient that the only person who said anything about this is the person who's currently staring down the barrel of a felony conviction. They have a profound motivation to lie. So like basically that anything the defendant says with no corroboration from anyone else, it strikes me that a prosecutor is going to argue and a jury might say, He's lying. Of course he's lying. And the reason he's lying is because he's guilty. So, like, he can't tell the truth, because if he told the truth, he'd admit he did it. So that, my worry is that a jury might very plausibly be inclined to discount heavily anything that the only source of is the defendant. And so I don't know, in response to the argument, it would have been helpful to have evidence from other people. The MAR court says, well, they heard it from the defendant himself. And I'm not sure that really responds to that. So I want to give you an opportunity to explain why I'm wrong to be concerned about that.
Yes, Your Honor. I think in this situation, looking at exactly what the defendant is claiming these records revealed, and that he could have used this evidence here at trial
To
make a
corroborate what he
difference.
said, right.
Well, correct. And I think the big piece is this additional sexual knowledge that he is saying sex abuse occurred from the older sister. Even had that evidence been introduced, we would argue, as argued in the brief, that it is very distinctive, and that distinction is very important here. So the jury would heard evidence that he exhibited male-to-male sexual behaviors involving other males, and that is very important.
But that's not really responsive to my question. The question I asked is, why shouldn't I be troubled when the MAR court says one of the reasons that something is no big deal because the jury heard it from the defendant himself? And I just suggested to you that I don't really think that's a plausible response. Are you defending what the MAR court said about that, or are you saying that notwithstanding that was problematic, we still, under EDPA deference, we still defer to them?
I would agree with that, as well as considering.
Sorry, you would agree with what?
That it would not be problematic and under the facts of this case.
Why isn't it? Well, I won't repeat the reason I
Right.
think that's problematic. Why isn't it problematic for the reasons I just gave?
Because of the other evidence in the case and the other evidence that the jury heard in this particular case.
But I'm not talking about that part of the MAR court's opinion. I'm talking about the part where they said it's no big deal because they heard these things from the defendant himself.
But I think if we're looking under Strickland and we're strictly under prong 2, we would consider that, and we would consider all of that evidence. And I think that evidence would be pivotal, and it goes into the jury's entire interpretation and how they look at the evidence and how they infer certain facts of the evidence and apply the law to the facts. So I think it would be very important, and you could not exclude what the jury heard. And the jury did hear testimony from Cold and Quick about the distinctions, and that little kids define relationships and identify relationships with male and female relationships solely. However, here, the evidence that we're talking about that would have been helpful from petitioner is the fact that his older sister, who was 4 years older, allegedly sexually abused him when he was at least 4 years old, prior to going into the Steen's custody. However, that would not be of any consequence here to the facts of this particular case, because we have that male-on-male interaction, which is very distinctive. Cold and Quick, as well as Ms. Holland, both stated that, and they both stated that concern. In fact, I think Mr. Quick and Ms. Holland both noted those distinctions. As well as after the period of concern, all of his sex behaviors exhibited were towards males. There was the incidents with the group home back in 2009, which was the last incident, which was the incident that occurred when he was removed from Mr. Steen's custody, that involved anal sex with males where they took turns. Petitioner says that distinctions does not matter. However, we think that is very important. It's very pivotal to the decision in this court. That was part of the evidence. In addition to other parts of the evidence that was presented, Mr. Steen's reaction on February 13, 2009, once the school called to let them know that MS had actually gone under the bathroom stall to sexually exhibiting sexual behaviors towards another child in the bathroom, Mr. Steen's immediate reaction, not where did he get that from, his immediate reaction was to blame his brother Richard. It was convenient. It was convenient. Why? Because he knew
I agree that's a very, very bad fact for the defendant.
So looking at the totality of the evidence, and under Strickland prong 2, that's what we do. We don't set out any other part. We look at everything that a jury heard. And the Court of Appeals opinion did exactly that as the prejudice prong. And in reaching, and looking at each of those, they reached a decision that it was not an ineffective assistance of counsel claim.
Could I ask you to respond to an argument that Mr. Steen makes that I want to make sure I understand?
Sure.
So they basically have the argument, it's true there was this other evidence, But this other evidence was different in character because the evidence the jury heard was about witnesses being said, like, how might a child have acquired this knowledge? This is like he could have witnessed something. He could have witnessed something in the home. He could have been exposed to sexually explicit material that no one his age should be exposed to. But the evidence that the jury heard, my understanding, maybe with the exception of the incident involving the boys, was much more of the nature of how could a child of this age have learned for this. And I understand Mr. Steen say that's different from saying evidence that he in fact did learn about stuff like this from this very specific instance. The argument I think Mr. Steen makes is that is a difference in kind. For like offering a hypothetical possibility about how someone might have learned something is very different than, which sort of falls under the like, is it possible? And then the response from these, the smart alecky expert witness is like, I mean, anything's possible, counsel, I guess, right? Like anything's possible, right? Versus, oh no, it's not possible. Here is where this thing actually happened to him, so he definitely knew about it. And they argue that's a difference in kind, not a difference in degree. What is your response to that?
My response to that is that the jury heard about these, I guess MS's behavior in general, and it heard about he came from this troubled home. They considered all of this. Yes, that was the state's theory. However, no expert said that the defendant in fact sexually abused this boy. Why? Because it's forbid under state v. Sansel in North Carolina. So the expert didn't say that. However, there were breadcrumbs left to draw to that reasonable inference, and the jury was allowed to make those reasonable inferences based on the evidence. So again, under prejudice prong 2, considering all of the evidence in the record and what the jury heard, and if we note all of that evidence, and there's not a reasonable probability that the jury would have reached a different verdict had they had the benefit of this additional information that he was sexually abused by his sister, MS, his older sister. So considering, again, I think I've belabored the point of all of the evidence, and kind of going back, recapping to the petitioner's admission, which is, I think, very fatal here in this particular case versus Mr. Letford's reaction to that, as well as the male-on-male distinction from the male-to-female sexual behavior. Considering all the trial evidence the jury heard, there's not a reasonable probability that the trial counsel requested these records, the jury would have reached a different result. The state court decision should be upheld. Trial counsel conducted a reasonable investigation, made strategic decisions entitled to deference, and did not provide ineffective assistance of counsel. If there are no further questions, the state would ask for this court to affirm the district court's order granting respondent's motion for summary judgment.
Thank you, Ms. Lawrence.
Thank you.
Thank you. First, I would like to address kind of the character of the information that the jury heard about MS lying and the information in the person-centered plan. And I think this court said it very well in Love v. Freeman when it says, there is a marked difference between evidence that a child has lied occasionally in the past, a fairly typical and benign scenario, and evidence that social workers, school counselors, and foster parents believe the child can lie and does lie through her teeth and lives in a fantasy world, an unusual and much more sinister scenario. The information the jury had was more in the former category. He lies no more than the average kid. He doesn't lie about this type of thing. The evidence in the DSS records, shows that this child has a serious problem with lying while he's testifying under oath. and he lies about these kinds of things. So I think the nature of the evidence is very important. As for the showers, Mr. and Mrs. Steen received MS when he was 4 years old. They wanted to keep him. They had him for 2 years. They wanted to adopt him. They treated him as their own child. There was testimony that MS took a long time bathing, was not good at cleaning himself. And so what Mr. Steen said that when they were in a hurry, he would hop in the shower with MS. His wife would be in the bathroom kind of waiting there with a towel. And when Mr. Steen was done cleaning MS, he would hand MS out to Mrs. Steen, and she would go take him and get ready, and Mr. Steen would take a shower. Now, hindsight being 20/20, that was certainly an unwise decision. However, it doesn't indicate that anything happened in the shower. It's not proof that MS was molested by Mr. Steen. Also, the incident with the brother. MS was at school. He climbed under the bathroom stall. There was sexual contact with another child. They call Mr. Steen in, and they ask him, how does he know this? Like, why is he doing this? What's going on? I mean, that was the question that everybody asked MS once his behavior was out of control. And Mr. Steen was not covering for himself. He was trying to come up with an honest answer. He should have reported. I mean, what happened with Richard should never have happened. And it certainly should have been reported, and Mr. Steen was wrong not to report it. But his offering Richard as an alternative or as a possible source of this knowledge is not indicative of his guilt. It was the explanation that he honestly came up with when asked the question. So again, this was a credibility contest. And the child that the jury heard about was very different from the child in the DSS records when it came to credibility. And the home that MS came from, the description was he was taken from the home. This was a home that the mother was neglectful because her boyfriend had committed suicide a couple months earlier. She became depressed and couldn't care for the children. MS came from a very different home. There was a lot of things, to say the least. It was a house of horrors, and it was horrible. And it explains a lot of his behavior. And the jury never heard about it, and they should have. And if they had, there's a reasonable probability that the outcome of this trial would have been different. To find that Mr. Steen did not receive ineffective assistance of counsel is objectively unreasonable and a clear violation of U.S. Supreme Court law. And we ask the court to grant Mr. Steen relief.
Thank you, Ms. McNeil. Appreciate it. I see on my court sheet, Ms. McNeil, that you are court appointed. I want to thank you on behalf of the court for taking on the appointment. And, these cases are challenging for a host of reasons. And so we are grateful to you for taking it on. We'll come down and greet you and move on to our second case. Be seated. Our second case is 25-2037, Ramos versus Blanche. Mr. Winograd?
Thank you, Chief Judge Diaz, and may it please the court. The primary question in this case is whether the crime of embezzlement in Virginia categorically involves fraud or deceit. The court should hold that it does not. As the Supreme Court made clear in Kawashima, a crime does not involve fraud or deceit simply because it is dishonest from an ethical standpoint. It involves fraud or deceit only if it requires the offender to engage in some type of misrepresentation. And Virginia's embezzlement statute contains no such requirement. The Virginia Supreme Court has held that embezzlement requires an intent to deprive, not an intent to deceive. That's why people are routinely convicted of embezzlement for engaging in garden variety theft from their employer. And that's also why the Virginia Court of Appeals just last month upheld the conviction of a business owner for failing to remit tax money that he owed to the county. And because people can be convicted of embezzlement without engaging in any misrepresentation, it does not categorically involve fraud or deceit.
Can I just ask you something that's around, this is about the facts, this is not about this, but what is the practical effect of the fact that USCIS has now approved his family-based visa petition? I saw that and I was confused and I don't know what to do with that piece of information. What does that mean?
It means that if he was still in removal proceedings, he would be eligible to apply for adjustment of status. But given that he's now under a final order of removal, it would make no difference unless the case is remanded.
Got it.
Can I also ask
Yes.
another procedural question?
Sure.
So he was a lawful permanent resident when removal proceedings were initiated, right?
Mm-hmm.
So why was there a requirement to apply it again for LPR status if he was already had that status?
Adjustment of status is a form of relief from removal. That's just how it's developed over the decades, that in order to avoid the effect of the finding of removability, he would have to readjust status and become an LPR once again.
So start the process all over again, essentially?
Essentially, yes.
Okay. Can I ask you then, you started off with this notion that the Virginia statute here is not categorically
Yes.
a crime of fraud. So is our decision in United States v. Good in footnote 5 where we essentially say that under Virginia law, embezzlement is also, well, the government argued in that case that embezzlement is also theft, but we said that they are separate as a matter of categorical distinction. Was that just wrong?
I'm sorry, in good?
Yes, good. Our circuit.
Yes, theft and fraud are certainly distinct.
Right.
The part of good that the government relies on is the statement that, which we believe is dicta, that embezzlement involves dishonesty, fraud, and misrepresentation. Now, I'm not sure if that's what Your Honor is referring to.
Well, maybe.
Let's assume-
Or footnote, okay.
Go ahead, no, go ahead.
Let's assume I'm asking you about that language, because I would like
Okay.
to know about that language.
Sure. So we think that is a quintessential example of dicta. It did not address the precise question at issue in this case. It wasn't necessary to the outcome. It easily could have been deleted without impairing the analytical foundations of the whole thing. In fact, if the court simply redlines the statement that the government is relying on, followed by the word indeed in the next sentence, it literally makes no difference to the outcome of the decision. And I would also note, the sentence after the one on which the government relies is far more equivocal than the government suggests. It says that if the statement on the application was phrased in using the word involving, then it might well have been false. That's not even saying it would be false. But even in a world where that statement is regarded as a holding, we would argue that it cannot be reconciled with the Supreme Court's intervening decision in Kawashima, which made clear that a crime that can be committed without making a misrepresentation does not involve fraud or deceit.
So can I ask you about?
Yes.
I think I know your answer, but I just want to make sure I do. So this statute, among other things, has the word fraudulently in it. And is your argument essentially like, I mean, this is the weird thing about an Erie world. Like, we live in a world of Erie Railroad. So under Erie Railroad, state law means literally whatever the state Supreme Court says that it means. And you might say, like, if this was our federal statute, you might think that it requires, well, fraud or something fraud-like. But the Supreme Court of Virginia, or Virginia's courts, you marshal these historical sources in your brief, have said, notwithstanding what you might think, person living in 2026, the word fraudulently does not necessarily mean what you might be inclined to assume the word fraudulently means. That's basically, and that because we live in an Erie world, if that's what the Virginia Supreme Court says, then that's just what this law means. That's basically your argument there.
Yes, we think both as a matter of original intent of the Virginia legislature,
But who cares? I mean, because from my perspective,
sure.
I don't care what the legislature of Virginia meant. I care what the Supreme Court of Virginia says Virginia law means.
And the Supreme Court of Virginia has never interpreted the term fraudulently in the embezzlement statute to require any misrepresentation. It is interpreted to require the same intent that is required to commit larceny, which is knowingly depriving the victim of property without any bona fide basis.
Okay, so like larceny would be, I walk into a convenience store and while the teller is not looking, I grab a candy bar and walk out, right?
Yes.
I don't lie to the teller. I don't have a Confederate who says, hey, distract the teller. I just rely on the fact that the teller is not looking at me at the moment and I grab it and I walk out. I've definitely committed larceny. And I've definitely had a culpable mental state, but I haven't deceived. The idea there is I haven't deceived anyone.
Correct.
I did that. Okay.
And this court has made clear in Solomon and Manna that for that very reason, embezzlement does not qualify as a theft offense. But the point is, nor does it qualify as fraud, because fraud requires, under Kawashima, some type of misrepresentation. Now,
Even in the employer-employee context, where at least there's some implicit notion that when you take on work as an employer, you're not going to steal from your from your boss?
even if there's a societal implication that you do that, the difference between embezzlement and fraud is that in fraud, the intent to deceive has to exist at the time the statement is made. In embezzlement, a person can take a job without having any intent to later convert property that is entrusted or delivered to him by virtue of his position. That intent, the intent in embezzlement arises after, at the time of the misappropriation, not at the time that they either receive the property or at the time that they receive the position that allows them to do that. But even putting the employment context aside, just look at Peary, the most recent decision from the Virginia Court of Appeals. The defendant was convicted of nothing more than failing to remit taxes to the county that he had collected on their behalf from his customers. He didn't lie about how much he owed. He didn't otherwise try to mislead the county. He just failed to pay taxes that he knew he had to pay.
Presumably that individual submitted a tax return, right?
He submitted tax reports, yes, which by all accounts were accurate. They were late, but he wasn't convicted.
I guess what I'm saying is when I submit my taxes, I disclose the income I disclose, and at least depending on how the language of the tax form writes. When I submit my tax form, I also represent, and I don't have any other income that's not listed on this form, right? Like, I presume the forms that I submit say something like that, right? Like, not just this is my income, but this is my only
I love
income.
that you have to presume what the tax form says. Maybe read it next year.
Right. But it says, right, like, that I'm not just representing that I made the money that's on my tax form. I'm also representing that I didn't make money that's not on my tax form.
Certainly, but I think Peary is on all fours with the hypothetical in Kawashima. Again, the hypothetical in Kawashima was a taxpayer who files an accurate return but moves his money beyond the reach of the IRS. And the Supreme Court very clearly said that does not involve fraud or deceit.
It's a little different, though, right? Like, I mean, it might be helpful to you, but it's not the same, because it's a scenario where, as I understand the most recent Supreme Court case, they're like a business, and they are collecting effectively like sales tax that is the government's, right? This isn't like, Judge Hyten's paying his taxes as a percentage of his income. They're getting this money effectively as like a bailee, right? I mean, it's in no sense their money. It's not their money when they collect it. It's not their money when they don't give it. So it's not like the tax case in Kawashima, right? Because actually in that instance, it wasn't the government's money to begin with.
That's a distinction. We don't think it's a material distinction. The analogy we're trying to draw is that the hypothetical taxpayer in Kawashima and in Peary, no misrepresentation was required. If you just modify the facts of Peary to say that he filed his tax forms on time and completely accurate, and they were completely accurate, but he nonetheless refused to pay the taxes for whatever reason, he would still be guilty of embezzlement. I don't think there's any dispute about that. And he would be guilty of embezzlement, notwithstanding the fact that he was otherwise completely accurate in disclosing the amount of taxes that he owed. That's the point that we're trying, the analogy we're trying to draw between Kawashima and Peary.
And to the extent that Good, and I guess the other case is Wells that the board relied on, say otherwise, that's just flat wrong as a matter of statutory interpretation?
Yeah, so, well, I discussed Good, but in terms of Wells, yes, fraudulent intent, as used in Wells, is synonymous with felonious intent, as is used in the context of larceny. I mean, Wells is a decision of the intermediate appellate court. I think the decisions of the Virginia Supreme Court are much clearer. So if you go back to Vaughn from 1920, it cited Wharton's treatise for the proposition that fraudulent and felonious were often used synonymously. In Page from 1927, the court said that fraudulent intent was synonymous with criminal intent. In Pierce from 1964, the court said that fraudulent intent was required for robbery, which by definition must be committed by force, not fraud. And then most importantly, in Bain from, I believe, 1974, the Virginia Supreme Court specifically said that the term fraudulently, as used in the embezzlement statute, was distinguishable from the civil definition of fraud precisely because it doesn't require any misrepresentation. So I think Bain especially makes clear that the term fraudulently, as used in the statute, and fraudulent intent, as is often used in judicial opinions, does not mean the intent to deceive. It's simply the intent to deprive without any bona fide basis, which again is the same test to determine whether someone had the animus furundi for purposes of larceny.
Can I ask, you keep using the word misrepresentation, and I just want to make sure I understand your argument. Do you think it's limited to misrepresentations, or could fraud or deceit include omissions of material facts?
No, we don't dispute it could include omissions.
You just kept saying misrepresentation. I just want to make sure that.
Sure.
And that's fine. I'm not complaining about the way you're framing it. But
Yes.
can you just walk me through sort of just a minute to I think what was the chief's question in part? Is this sort of omission that if somebody is giving you property, right? So if you're, the rental car example, which seems to come up a lot, but the tax guy is the same one. If somebody's giving you property that is not yours, that there is, I don't want to bastardize the chief's comment, but there's this implicit,
Sure.
Statement or promise that you will use it in the manner in which it has been given to you. Right? If I'm the valet and somebody hands me the keys, I don't go on a joyride from Ferris Bueller's Day Off, right? I go park it in the lot, right? And if I do something inconsistent with that, or if I'm going to do something, or I do something, that there's an implicit representation that I'm not going to do that. And if I omit to tell them either at the time or when I develop that desire later, then that omission, the failure to notify the true owner of the property of my, decision to misuse the property, whether it's at time 0 or time 1, that's an omission that is itself deceitful merely because, unlike the tax case, this is somebody else's property.
Sure. I think you can only look at time 0 at the point that the property is entrusted or delivered to you.
I don't think so, right? Once you admit it's an omission, right? It's a failure to notify. I get if it's just a misrepresentation, there's only one set of representations, and that was at time 0. But an omission is different. So a failure to notify, a failure to provide information is an omission. Right? It doesn't require that I'm speaking in order to do so.
By omission, I mean, as this court put it in Solomon, the concealment of that which should have been disclosed. So
right,
you can't,
and what should have been disclosed, this is the argument, right? What should have been disclosed is that even if I, took the valet keys, took your car with the sterlingest of intents, the vintage Ferrari overcame my willpower, 15 minutes later, and I was simply unable to comply. But that I have an obligation to notify the person who provided me that Ferrari that my view has changed and I'm now going to misuse their property.
Sure, I just think that's conflating embezzlement and false pretenses, which are two separate crimes. And they're
No, but it's not completing it, right? Because the question is whether there's a material omission, right? And if you have some obligation to do with somebody's property what they have defined it for you, right? Go park my car. If I change that, I have an obligation because it's their property. They own the property, unlike in Kawashima where it wasn't the government's property. But when they own the property, that's part of the representation that you make at the beginning, and you have a continuing obligation to not omit a change in your intention.
right. I just think, think of it that way. I just think transforms embezzlement into false pretenses in that it extends the moment where the property comes into possession for the entire time you have it in your possession.
But false pretenses is limited to the very question of, are you doing it at time zero? Right? And we can all sort of acknowledge that even though there's false pretenses, embezzlement, and larceny, they're not siloed, right? There's going to be overlap. There are going to be instances in which a given crime could be charged in more than one way.
At the state level, that's often the case, but this court has siloed theft and fraud. So I think Solomon and Mina make clear that theft and fraud are mutually exclusive, or this court treats them as mutually exclusive for purposes of the INA. And I think embezzlement is different from both of them because it doesn't require a trespass in the taking.
So your view, so in response to my argument, what you say is because that could be charged as false pretense, it could not be charged as embezzlement.
No,
That doesn't seem right.
No, that's not what I'm saying. I'm not saying.
Then I'm not understanding. Give me one more try.
I'm saying the way you are characterizing this continuing duty to disclose or not omit, I think would make embezzlement a form of false pretenses for the entire period that a person has the property in their
that
possession.
means it's not just false pretenses. It's something different, right?
I think what makes embezzlement different is that one does not have the intent to convert at the time they come into possession of the property. And because they don't have that intent at the time they come into possession, there is no duty to disclose at that time. And I don't think there is a continuing duty to disclose.
It's sort of an omission of a pretty material fact, right? I mean, you think of deceit. Take deceit as the example. It's an omission of a material fact. If I've taken your car under the implicit promise to park it, even if I intended that at the time, but if I change my mind and I'm like, I am joyriding this thing into the ground.
But there's no longer even an opportunity to inform them. Today, sure. Today we have cell phones.
You should go back to the restaurant and you should inform the patron that I'm getting ready to go take your car for a joyride, so that you have the opportunity to revoke the limited license you gave me.
Okay, well, I mean, that's a valet at a restaurant. If we have a valet at an airport and the person's flown to another city, there's no opportunity. Maybe today with cell phones, yes, but historically, there was never that opportunity.
Greg, I'm
Yes.
sorry to interrupt, but even if under Judge Richardson's hypothetical, Virginia might prosecute that as an embezzlement, the fact remains that they prosecute something less than that categorically
Sure,
as
yes.
theft. So it doesn't matter. We look at the least culpable actions that could be prosecuted under this statute, and the fact that it might also include all of the various hypotheticals that Judge Richardson just launched at you is not the question.
I couldn't agree more. And yes, there may be many instances of embezzlement that do involve fraud or deceit, but categorically they don't require.
Could I ask you two questions about this statute? Does this statute require a fiduciary relationship between the defendant and the victim?
This court made that clear in Open Risk, citing Chiang, authored by Judge Keenan when she was on the Virginia Court of Appeals.
And then the second question is, do you understand the federal statute as requiring fraudulent or deceitful? Is this a mens rea requirement or an actus reus requirement? In the sense of, is the question whether the defendant had a fraudulent or deceitful intent, which would be a mens rea issue, or whether the defendant did something that is fraudulent or deceitful, which to me sounds like actus reus.
At a minimum, it requires the actus reus of some type of misrepresentation.
So the fact that I, in my heart, tend to do something super sneaky is not enough?
I think the court can save that for another case. We haven't raised any argument related to a specific mens rea or materiality, but I think at a minimum, it requires an act of misrepresentation.
And, so and in Kawashima, for example, you filled out a tax return that said, this is everything I owned. But it's not everything you own, so when you filled out a tax return saying, this is everything I own.
No, that's not what it was in
Sorry,
Kawashima.
thank you. I realized as I was saying, it's like, I'm not sure
No.
I'm right about this, but I wasn't. No.
Kawashima specifically referred to a taxpayer who filed an accurate return, but nonetheless moved his money beyond the reach of the IRS. And it
No,
does
no,
not.
so what Kawashima said about the reason that the primary defendant in Kawashima had in fact committed fraud or deceit
Oh, yes.
was because you filed a tax return that said, this is everything I owed, and it's not.
I don't know the exact facts, but the return had materially false information.
The information it was not true.
Right, and the court emphasized that it involved fraud or deceit, or deceit, not fraud, precisely because the return included materially false information.
Can I ask one follow-up
course,
to the
sure.
chief's question? Sorry, chief.
Go ahead.
So the chief says, okay, but these crazy hypotheticals that Judge
call them
Richardson, I can read between the lines. These ideas, but there's something less. And so I guess what I'm trying to understand, or there's something that would be prosecuted that doesn't involve this idea that I was trying to get at. And I guess I'm curious, you sort of agreed with it, but didn't explain why. Because as I understand embezzlement, it has to, the least culpable piece of this is that it involves property that was delivered by another. Could be entrusted, but we sort of acknowledge that's probably an easier example in your mind. And then, we talk about this employment as the third example. It's got to be one of the three. It's got to be employment, right? Some version of that, or by virtue of trust, office, trust, employment, or which shall have been delivered to him by another. That seems to be the least culpable piece. Do you agree with that part?
I think so.
So
I
can
think
give
that's
you a
Puri.
hypo? What if someone, go ahead.
No, go ahead.
What if I get at my house a check that was intended for the previous owner of my house, and it's mailed to me at my house? I didn't ask for it, I didn't invite it, I have no relationship whatsoever with the entity that sent me the check, and I cash it. For reasons I don't quite understand, my bank lets me cash that check. Have I engaged in fraudulent or deceitful conduct there? Well, have I committed embezzlement in violation of Virginia law? I think I probably have.
I think you have. I think you would necessarily engage in fraudulent or deceitful conduct by cashing the
a check.
check.
That's a bad example. What if I just keep it? All right, what if someone just mails something to me that they clearly didn't intend to mail to me, and I just keep it?
Pretend it's cash.
No, or it's chocolates, and I eat them. It was delivered to me by another.
Yeah, I suppose, yes, that could be embezzlement. Now, there may be an abandonment claim or something like that.
Oh, I know
but
it was
yes.
addressed to someone who wasn't me.
Okay, then yes, I think that would be qualify as embezzlement under Virginia case law. I believe it would.
I'm good.
Okay.
Thank you very much.
Thank you, Your Honor.
Ms. Gordon?
Thank you. May it please the court, I'm Virginia Gordon for the respondent. Your Honors, as my colleague said, the primary question is whether this categorically involves fraudulent or deceitful conduct,
Can I
and
ask you a
the
threshold
embezzlement
question
does.
here?
Yes.
Why was he removed before there was a final order of removal?
There appears to have been an error
That
on
seems
the
like
part
a
of-
really, really, really big screw up, removing someone who doesn't have a final order of removal.
Yes, Your Honor, and he was brought back because of that error once it was made evident to
Have steps
our
been taken
office.
to figure out why that happened and ensure it's not going to happen again?
Yes, we constantly do make steps to make sure that those things don't happen again. I know that my colleague who was working on the case had multiple conversations with the Department of Homeland Security. So, but he was brought back because of that. So, and from our understanding, in the same position before leaving, that departure does not affect his status. But unfortunately, the conviction that he faced does affect his LPR status. And we do believe that embezzlement under Virginia law meets the definition of fraud or deceit under A43M Romanet 1 because those that is a broad statute, as the Supreme Court had stated, and when we're looking at involving fraudulent or deceitful conduct, everything that even was raised today for embezzlement involves fraudulent or deceitful conduct.
What about my chocolates hypo?
That could be considered deceitful conduct.
Who am I deceiving?
Because
I
it's
haven't said
concealment.
I have not said anything to anyone.
But there is a concealment, and that's the
By
part that my
eating them?
colleague hasn't.
By
you-
eating the chocolates?
You've concealed, I would argue that you concealed that you know the chocolates don't
Fine, let me
belong to you, and they
change-
belong
fine,
to
let-
someone else.
Let me change
and
the
that-
hypo. The hypo
Okay.
is now like a pretty little clock, and I put the pretty little clock on my mantle. I don't consume the clock. I don't destroy the clock. If anyone ever asked me, I said it was a bizarrest thing. One day someone mailed me this clock. And like, I'm not hiding it for anyone. It's literally on my mantle in my living room.
I don't think that that would be convicted as embezzlement, but it just
Why
doesn't
not?
seem
I'm
to
looking
match
at the statute. That seems to violate the statute.
The statute requires that it can be either wrongfully or fraudulently using, disposing, concealing, or embezzling this tangible and
I'm
intangible
using
property
it.
of another.
I'm using it.
Yes. Did you receive it for the another or by virtue of your office, trust, or employment that you
It was
were
delivered to me
delivered to
by a company. It was
A
sent to me
company?
by the
We'll
clock
say that
company.
the
The clock
clock
was
company
delivered to me
sent
by,
it
or UPS, or FedEx.
and it was sent to your name, not the other.
No, it was
person's
addressed.
name.
It was addressed to someone who's not me. But it was delivered to me.
Right. So I think that's where the difference would be. I don't see the cases in Virginia law saying that because it was delivered, if it was delivered to me, but I didn't receive it. So it was mailed to me, but I never received it, then it never was delivered to me. But it was
No, but I'm the
delivered to
defendant. It
you,
was-
but you, I think I'm just turning the hypothetical in a bad way. I don't see embezzlement being charged for that situation, even
You
with
would
the
say
use.
that because it wasn't addressed to him, it wasn't delivered to him by another. That
Right,
delivered to
yes,
him, I don't know whether this is right or not, but like, that delivered to him doesn't include when something is lost, which
Right,
is
mistaken.
effectively if I mail it, to Chief Judge Diaz, but I use Judge Hyten's address, and Judge Hyten decides to keep it, seems like a likely scenario given his hypotheticals, that is somehow me delivering it to Judge Hyten's, right? That's a mistake, that's not a delivery.
That's not a delivery. And so when we look at the delivery example, the rental car example with the friend who rented a car to bring her friend home from the hospital, well, she delivered, she had a headache, so her friend said, "Can I use the car? I need to go get my medicine." She delivered it to her. It was a direct exchange. And then her friend decides to go take the car and cause damage and take it out of state. And that's a delivery. So I don't see the example of a mislabeled mailing or the post office inadvertently
Who is
delivering
the
to you.
embezzlement of in the rental car example? Because the renter and then the joyrider
Right.
and then the rental company, it was embezzled from the renter by the joyrider?
That is, what it seems to be is that she was embezzling because she met the elements of this car was delivered to her. It was not her property. Technically, it was Enterprise's property that was
But sort of
in the
transferred
trust
through
through them. And what
Am
the
I understanding you to
broad-
say that there needs to be a delivery of property of some kind to another? or-
That can be. There are multiple ways it can be. So a delivery of property is one. There is a fiduciary relationship is one. The employer-employment relationship. So any of those three do fit the embezzlement statute for Virginia.
But we agree that the board in this case, no one is talking about the modified categorical approach in this case and whether
No.
this is divisible. So we have to
Right.
assume the least culpable conduct that violates this statute.
Right. And
And all of the
it
examples
appears-
that Mr. Winograd suggests in his brief all appear to involve the employee relationship, and you think that's perfectly fits comfortably within the statute?
fits within the embezzlement statute, which then meets the INA's version of, which is just involves fraudulent or deceitful conduct. And I know the issue of conduct was raised earlier, that the involving the fraudulent or deceitful conduct, and we've spent a lot of time, and my colleague, Mr. Regatta, spends a lot of time talking about the fraudulent intent, but not the concealment. And Kawashima explained that deceit involves falsification, concealment, or cheating. So concealment is what we see in many of these Virginia cases. There's a concealment. An individual has an employer-employee relationship to manage their cash register properly, and yet they give false discounts to a customer or give free items that they're not supposed to. They've concealed there's
But
concealment
what
in there.
about
There's
what
concealing
about the employee who just raids the supply cabinet? What have they concealed? So
think
if
they
one of my law
conceal-
clerks just like literally goes into one of the supply doors and goes to town because they're having a party that weekend and they don't want to buy supplies, what's the concealment? That's embezzlement, but I'm not sure what the concealment is there.
I think we could say they've concealed or they have violated the trust, so they've concealed that. The way we're understanding the concealment, the way we're looking at it is that
That any violation
got
of a fiduciary duty is necessarily concealment?
No, not that, because I think we'd have to look, I think in that case, you do have to see what happened in the case, but we know that it can be a violation of a fiduciary responsibility that can be taking money and converting it to something else. It can be concealing it would be concealing I think the best example I have is when we look at the scrap metal that was involved here. The individual, Mr. Ramos, concealed that this doesn't belong to him. He took the scrap metal
It's
that
the
belonged to his
omission of
employer.
a material
It's-
fact. It's not
yes,
really
I apologize.
concealment, right? That's like a piece of it. It could be concealment, right? But
Right.
really what it is an omission of a material fact.
Right.
And whether it's an omission depends in some degree, it seems like to me, for your argument, on the existence of some relationship that makes that omission problematic. And an employee-employer relationship would be one of those, but, the delivery of a vehicle to you would be another type of relationship
Yes.
that would warrant, like, telling them if you've decided to go joyriding, right? Like, and the same thing, if I, use my valet example, right? I now have this obligation to notify you if I'm doing something different than what would have been understood at the time of the original transfer.
Yes, Your Honor, I see it as that way. And if we were raiding the supply closet, we're engaging in an act of omission. I should let you know, I really don't
What
have
if they're
money
being
to buy.
extremely open and notorious? Like I walk
Okay.
out in the hallway and I see them doing it.
It just seems to me that wouldn't end up being convicted under embezzlement, but I think
It seems to me like what you're really saying is that any crime that involves sneaky or dishonest intent is inherently dishonest or deceitful conduct. That seems like what your actual argument
Okay, I
is.
apologize. So I think I should bring it back, because actually, when we look at the categorical approach in this instance, because it's broad and it's involving fraudulent, deceitful conduct, all of the elements include that, and so we don't have to look at the facts.
Well, so
We
can
are
I ask
just
you, okay,
looking
so
at
how
the
much does your
elements.
argument depend on the fact that this statute uses the word fraudulently?
It can be fraudulent or intentional. So fraudulently, the Virginia statute uses the word fraudulently because one of the ways that it can
But your friend on
be
the other
writ-
side says fraudulently as used in this statute doesn't mean fraudulently the way that people who live in 2026 understand that word. And we know that because of the common law and what the Supreme Court of Virginia has said. And I don't really see a response to that in your brief.
Right. Looking at the older cases, we've seen some development, and more currently, the Virginia courts are talking about fraudulently as a wrongful or
But
fraudulent
how?
use.
Wait,
that
hold on.
it's-
Like,
that
for me,
there's-
the giveaway that something is deeply
Okay.
weird about how Virginia is using the word fraudulently is the case where they said that robbery involves fraud. It was like, no, it doesn't. Under no conceivable modern definition of fraud does robbery involve fraud. So that to me is a pretty strong clue that when we use fraudulently as a mens rea term in Virginia, we do not mean what we moderns think of by fraud, because I don't see any modern definition in which robbery involves fraud.
Yes, Sharon, I don't see that either. I think that case law has evolved. I don't think it's addressed that, so I can't say that the Virginia court has said we made a mistake. But the cases that are addressing this embezzlement statute, and we look at Wells, we look at these other cases, they talk about fraudulently. Sometimes they'll use wrongfully, fraudulently, or feloniously. So they're not, if felonious and fraudulent meant the same thing, we wouldn't need a disjunctive phrase of those three words. And we've got there can be a fraudulent intent. Also, it can just be the receiving of the property. We don't have to have that intent for this.
Sorry to interrupt.
I'm sorry.
Just a follow-up to that.
Yes.
Does the fact that the Virginia courts seem to be all over the map on exactly how to interpret this statute, and of course, we've had this very spirited discussion as to where we should land, and I think Mr. Wintergrad mentioned this in his brief, although he didn't mention it when he came up to the podium. I think he talked about maybe applying the rule of lenity in a situation where a statute is ambiguous and suggesting there's just so much confusion here. In this case, that rule suggests that the petitioner should prevail given the ambiguity.
I think that I want to clarify the ambiguity. I actually think when we got into the discussion, and I went along with the facts, that we really just want to come back to the categorical approach requires
Do you think
just looking at the
rule of
elements.
lenity has any role to play in that analysis?
I don't think we do here, because in this case, the categorical approach is pretty clear. We have the
Is it really?
Supreme Court is.
Wow.
Ooh, don't make that argument.
Okay.
There's
I
never
won't
been a
say- it's never
categorical
clear.
approach
That-
case that's clear.
Okay, I'll be fair. The categorical approach is tricky. We know that. But in this case, when we're looking at the categorical approach, we have two ways that you can look at it. And as Schuler, the Supreme Court said, when you look at the categorical approach in a case that's involved with the phrase involving, like we have here, involving fraud or deceit, it's a more broad, it's not an element by element comparison. So we're not looking for a specific defined element that has to be met from embezzlement. We just have to involve fraudulent or deceitful conduct.
But I thought,
and
I thought your response to the chief might be that the rule of lenity simply doesn't apply in this context because there's not a criminal implication. So that's different in cases like Leocal, where they're both immigration and criminal implications. But I thought what you might say is the rule of lenity should not apply in the context we have.
And that is, Your Honor, thank you, that's helpful, that it should not apply here simply because I don't think that it's as ambiguous as we've started to take it to with the hypothetical examples, and I did go down
What
that
about
road
the
with you.
impact
but
of
we have-
Loper-Bright and the notion now that ambiguities in immigration statutes should be construed in non-citizens' favor?
I think that if you find an ambiguity, then that's something to discuss. We don't see the ambiguity here because we see a categorical match because it's involving fraud or deceit, and the Supreme Court has over time, and this court defining those two different terms. We have fraud can involve that intent. Fraud might have, the fraud that the courts have kind of described for this, it does have an intentional perversion of the truth, but deceit has an act or practice of deceiving with a falsification, a concealment, or cheating. And so either one of those
All right,
suffices
again, go back to
to
my
meet
clock
the
example. What's the
statute.
falsification, lying, or cheating that I'm doing there?
With taking a clock that was mailed to someone else, but you
I'm not
kept it.
falsifying. I'm not lying to anyone about anything. Anyone who asks me about that clock, I will tell them the absolute truth about where that clock came from. I'm not concealing it because it's in the front room of my house, and literally anyone who comes into my house can see it. And I don't know how it's cheat. We can describe a person who doesn't return something that they know was given to them by mistake as a variety of things. I just think it's weird to say that's cheating.
I think it would also
It's doing
be
something
weird.
sneaky and maybe bad, but it doesn't sound like cheating to me.
And Your Honor, respectfully, I think that would not be embezzlement under Virginia statute, even where they.
Why?
Because the delivery, as we discussed before, is not
And where
the
does
same
this
as
idea that
delivery.
if you know you're not the intended, I don't see a single Virginia case that endorses this idea that if you know it wasn't supposed to go to you, it wasn't really delivered to you. Because I would think as a matter of plain English, something that is in my mailbox was delivered to me.
And Your Honor, I respectfully just don't think that Virginia embezzlement would cover it. I understand that seeing it as delivery, it seems to me that would be
It's left
covered
on my
under a
front
different
porch.
offense.
I mean, there's some
Yes, but
evidence
there's no-
that it's never been prosecuted. I mean, we're not aware of any such instance in which Virginia is prosecuted as embezzlement. An instance when somebody received something addressed to a different person and they kept it.
Right, but what we
And
are
that's some
seeing
evidence
is
that Virginia doesn't interpret it that way, right?
Right, that the lack of that does, and when we look at the types of cases Virginia has used the embezzlement statute for, they don't seem to go that far. They do seem to have, this delivery was a known relationship between the parties that delivered the item. Or again, we have the employment or the fiduciary relationship. So because of what we see the cases doing, it just seems that hypothetical might go far, but I respectfully understand the delivery definition there could be confusing, but I think that when we just look back at the language, we involve fraudulent or deceitful conduct because either a fraud was committed, they engaged in an intentional perversion of the truth, or they got someone to rely on something. But even the fraud definition that this court applied in Solomon says it could be or by concealing something that should have been disclosed. And so if we did say the clock, it should have been disclosed that you kept the clock because you knew it didn't belong to you. You could say that, but I don't see the cases going that far. But this court has has given several disjunctives of what could be fraudulent conduct, and that even includes concealment of something that should have been disclosed. And
So I
then
wanted
we
to ask
have
you about
see.
the continuance issue, but if you have something you want to
Okay.
finish up on this, go. I don't want to
Your Honor,
get
that's,
you.
no, we just, just to reiterate, that we see that this statute does meet, it involves fraudulent or deceitful conduct, and I'm happy to talk about
So
the
on the,
continuance. Thank you, Your Honor.
on the, I think I've traced, or we've traced where I think this happened, but you agree that under the board's test, the question is good cause shown for a continuance. That's this test, right?
Yes.
And so your argument is that to the extent they said this stuff about full and fair hearing, that's just like harmless, erroneous stuff, but that's not the legal test, right?
The good cause shown is the legal test, and then what the board has done is they look for good cause shown for denial of the continuance,
And how
and
does
they're
the
not
fact
going
of
to
whether you got a
overturn.
full and, right, so but the
Right.
good cause shown is assessed at the time we're deciding whether to grant you a continuance.
And-
And so if that's the question, was good cause shown at the time, I don't understand how the fact that I later had a full and fair hearing has literally anything to do with whether there was good cause shown for having a continuance. So it seems to me like the board is like announcing different tests in the same opinion.
The board did discuss it in their matter of Perez Andrade, and so they cited that, where they talked about it has to be the good cause shown, they follow the statute, and then state, and we will not overturn the denial if good cause has been shown, unless it appears they've been
So that's
deprived
like a
of a full and
harmless
fair
error,
hearing.
like a prejudice requirement?
It seems that what the board seems to be giving it sort of a prejudice requirement, because they have said, we're looking for good cause shown. And if we see that good cause has been shown, unless there's not been a full and fair hearing, we're not going to overturn the IJ's decision, because it was the IJ had all the information. And as long as they applied the primary and the germane
Wait, I
secondary
thought I was
factors.
following you, now I'm confused, okay.
Oh, I apologize.
So, does full and fair come in after the board concludes there was good cause shown, or in situations where the board concludes there wasn't good cause shown?
That it appears that the board is applying it when they're looking at a denial of a continuance for good cause shown. So they
No, I don't,
look
I
for-
literally
I
don't.
apologize.
So the board thinks, does the board apply full and fair in situations where the board thinks, because all these cases are where the continuance was denied, that's the reason the non-citizen is appealing to the board.
Right.
So all of these cases involve cases where the IJ denied a continuance. Does the board apply, in your understanding, full and fair in situations where, like, we actually think the IJ might have been wrong about denying the continuance because there was good cause, but we're not going to overturn the IJ's decision because you still had a full and fair hearing, which sounds like a prejudice requirement. Or alternatively, yeah, like, does that help?
That does help. I apologize. Thank you, Your Honor. If the board believes that good cause were shown, from what we have seen the board do, they would probably send it back to the
Whether
IJ.
there
And
was a full
we're
and
not
fair-
going to
If-
see those
But
hearings.
if there's been some harm from doing so, right? I mean, agencies are entitled to use harmless error just like we are. And a board doesn't need to address, we talked about Strickland earlier, I know this isn't your world, but like, you don't have to address the good cause piece if you find no prejudice, right? And so often it seems like to me, the board is saying here, there's no prejudice from the denial of and they're not using those words, but that's implicitly what they're doing. They don't have to do that before or after addressing whether there was good cause. They can simply say, whether or not there was good cause, there's no harm in the denial.
And Your Honor, that the board probably could do, but I do think the board looks for good cause shown first, and that's how they've been interpreting it. If good cause was shown, then, and the IJ, and the board determines that the IJ erred on denying the continuance, then it's, the way it has phrased it, it would likely remand for the IJ to address it. But because they won't return a denial of a continuance where good cause is shown unless there's a full and fair hearing. So unless for good cause shown, but they're looking to see was it shown, and usually it has not. When they found it and we get to this point, it's because the board said there was not good cause, and the IJ was correct in finding that. And I hope I'm clearly stating that we'd first look for good cause. If there was good cause and the IJ erred, then it would be remanded under how the board has been doing it, but generally we're seeing now the denial, and they're agreeing good cause was not shown, and we're not going to send it back.
All right, thank you, Ms. Gordon.
Thank you for your time.
Thank you, Your Honors. I would note that we have proposed a test for when a statute involves fraud or deceit. The government, neither in the briefs nor today, has proposed an actual test. Their brief is filled with all sorts of amorphous phrases like betrayal of trust, bad faith, breach of honesty, want of integrity. But any number of crimes involve such conduct without requiring any sort of misrepresentation. Stealing from your roommate unquestionably involves a betrayal of trust. So does adultery, for that matter. But a person who steals from their roommate, like a person who cheats on their spouse, can do so without making any misrepresentation. So the government's argument at bottom, I think, conflates crimes that are particularly dishonorable with crimes that are necessarily deceitful.
Do you think that Virginia would prosecute those two examples as embezzlement, as under the statute?
Those particular examples, no, not embezzlement. But my point is, if you take the government's argument to its logical conclusion, it would seem to apply to the federal standard, fraud or deceit, would apply to crimes like adultery, or, I mean, stealing from your roommate isn't a crime unto itself. But my point is, there are ways to commit crimes that violate a sense of loyalty or honor, but don't require any sort of misrepresentation. And so if you take the government's, their test such as it is, it would, I think, expand it far beyond what Congress intended. Now, just returning to the idea that we have this implicit duty not to, steal from our employers, it's always implied that we're not going to steal from one another. That's why larceny is a crime involving moral turpitude. When I come into this courtroom, it's implied that I won't steal anything from it just by virtue of the fact that I'm a guest in this courthouse. With respect to Your Honor's question about concealment is not required. An employee could openly put their hand in the cash register and walk out of the store and commit embezzlement. You can think of it this way. Imagine there are two people at a store. One is a robber, one is the cashier. Both stick their hand in the cash register, take money out, and put it in their pocket. Neither one, that conduct is indistinguishable. Neither one engages in any misrepresentation. So neither we think would, and that would clearly be prosecutable as embezzlement under Virginia law. And if you look again at Peary didn't conceal anything. Sure, he was a little bit sketchy about when he was going to file the reports, but there's no indication in the decision that he lied about how much he owed. In fact, if anything, he overpaid how much he owed. The issue was simply that he did not pay money to the county that he knew, subjectively knew, he had to pay, and he had no bona fide reason not to pay. Therefore, he was guilty of embezzlement. On the rule of lenity, immigration does have a rule of lenity unto itself, even in cases not just the legal context where there's a cross reference to a criminal statute. Before Chevron, the Supreme Court repeatedly applied the immigration rule of lenity. Under Chevron, it was unclear whether it still applied, but post-Loper-Bright, Judge Sutton last year in a Sixth Circuit case that we cite in our brief, again recognized that the INA has its own rule of lenity. So if there is a provision of the INA where the interpretations are in equipoise, then you have to interpret it in the non-citizen's favor, just as you would in the criminal context. If the court has no further questions. Okay.
Thank you very
Thank you.
much, Mr. Winograd.
Good.
We want to thank both counsel for their excellent arguments this morning. We'll come down and greet you, move on to our third and final case. All right, be seated. Our third and final case this morning, 24-4059. United States versus Malacu. Mr. Newland.
Thank you, Your Honor. May it please the court. Do not think about prison as a way to rehabilitate. Those are the clear words of Justice Kagan in Tapia versus United States. is the clear directive of 18 U.S.C. 3624A. In this case, the district court committed plain error when it extended my client's sentence far beyond the sentencing guideline range to, in fact, the maximum for the purposes of promoting rehabilitation. The rehabilitation in this case being medical compliance with my client's intravenous drugs that he receives from FMC Rochester for schizophrenia. Over the course of 2 days, the district court extensively
Why do we even think about that as being rehabilitation? I mean, just as like a threshold matter, like, why is medical treatment considered rehabilitation? I mean, they seem quite different to me. I mean, maybe I just don't understand what the word rehabilitation means, but I tend to think that rehabilitation feels different than medical compliance.
First of all, I'm sure that Your Honor does understand the word rehabilitation probably better than I do. My response to that would be, in this context, in the argument that we're making, and when we say rehabilitate, I think it's illustrated by the fact of the judge saying, well, you're a danger to society, but only when you're not on your medication. Or you can come back and submit a compassionate release motion.
So take the example where a judge said, might be wrong for other reasons, but do you think it would violate Tapia if a judge said, I would otherwise sentence you to 6 months, but I'm going to sentence you to 2 years because you need a kidney transplant, and the BOP has a great kidney transplant program. False, by the way, but accept the hypothetical, right? Would that be a Tapia problem?
I would take it as a Tapia problem, Your Honor.
But why? Because we don't think rehabilitation as having better health we're not rehabilitating for a health perspective. We're talking about rehabilitating from your criminal proclivities.
Well, Your Honor, actually, if we look back at Tapia, the facts of Tapia are the residential drug abuse program. So, that is a mental health program, that is an intensive mental health program needing over 500 hours that, inmates have to complete. And the judge had extended the sentence to say, hey, I'm going to give you a little bit more time to make sure you can get through RDAP because by all accounts, you have a drug problem, and we want to make sure that you're able to do the intensive drug program. And on appeal, the Ninth Circuit said, yeah, that's fine. And the Supreme Court said, well, no. The exact words are, do not think about prison as a way to rehabilitate in the context of the RDAP program, which
let me give you that example because I think it plays on. Now, this is just suggests that the Tapia inquiry is really hard. But if a judge says the following, like one of the things I'm supposed to think about is incapacitation, right? And protecting the public from you. And I have this dilemma that I had a case a few years ago like this where the judge basically says, like, here's this dilemma. I have every indication that when you're properly medicated, you're not dangerous to other people. But I also have a lot of indication that when you're not properly medicated, you are extremely dangerous to other people. Which means that given that I have to protect the public, my answer about whether to release you depends entirely on whether you're on your medication. And then the judge says further, by the way, because of your extensive experience with the criminal justice system, I know that despite what you tell me right now, that you definitely promise Pinky Swear to take your medication from here on out, I don't believe you, sir. And I don't believe you for very good reasons involving your former conduct. So therefore, I guess I've just concluded I need to leave you in prison because that's the only place I can make sure you get your medication. Is that a Tapia violation? I'll just tell you that my instinct is it's not. That's about incapacitating the defendant.
I agree, Your Honor, and I think that's
okay,
about...
and that case is different from this case. How?
Well, I think the distinction is one of, candidly, quantity. If you look at the record in this case, how many times the district court talked about protecting the rehabilitation of my client specifically, and how he wanted a 20-month continuance from the first day of the sentencing hearing.
But isn't that because that's the argument that you made? I don't mean you literally, but your client made? I mean, your client said, it's a little hard to blame the district court for talking a lot about this, because it was the primary mitigation argument that was made, right? And so when you say, oh, well, it's quantity, if the district court hadn't talked about his, mental health challenges and the treatment thereof, you would be up here saying that the district court failed to adequately engage with the primary mitigation argument. But when he does engage with the argument that you've made, you now say, well, he engaged with it too much. Like, I get that we hold district courts to an impossibly high standard in sentencing, but this seems like even beyond what our court has demanded of district court judges.
Well, if I could respond, Your Honor, what I would say to that is, if we take the statement in isolation, for example, when the district court in this case said, exactly the hypothetical I think Judge Hyden's proposed. Mr. Malaco is very dangerous when he's not on his medication, and so X, Y, Z. I think if we have that alone, candidly, Your Honor, I don't think that's a Tapia violation. I don't think it comes close. And I understand that this is a lot of line drawing that we have to do here, and candidly, a lot of second guessing. But, the judge in this case, talked about.
When you say in isolation, do you think that that's what we're supposed to do, that we really try to identify sentence fragments to understand what was happening? Or do we look at the sentencing as a whole to try to make a judgment under Tapia as to whether the sentence was increased as a result of rehabilitation, in order to permit rehabilitation?
I think, Your Honor, you appropriately state the standard in that it's a holistic review, and we have to show that it's causally connected, right, to an increase in the prison sentence, which is where, when the judge talks about additional incarceration is necessary for additional medical care and those sorts of things, we think that goes to, again, the rehabilitation. And we think the very unique process of.
Why wouldn't we just say in that example, I'm not sure that's a great example for you, but assume that that's what was said. Given that we have all this discussion about how the medicine is necessary to keep society safe, why do you not have some sense of giving the district court the benefit of the doubt that when it's saying that, it's actually referencing what it's been talking about for the rest of the hearing?
Well, I think the district court is referencing, maybe I don't understand Your Honor's question.
So the better part of the hearing is you need this medicine because otherwise you're super dangerous, and we all acknowledge that incapacitation is a valid reason for imprisonment. And so when he says later on, and additional time for medication, why didn't we just think of that as incorporating the reason for the medication is actually incapacitation, not some form of rehabilitation post-prison time?
Well, I think considering rehabilitation within the prison setting is inappropriate, and I think that's the judgment that Congress has made with the Sentencing Reform Act of 1984, Your Honor. I think if we look at the structure of the sentencing, indeterminate sentencing that we had prior, is that courts routinely, punted these decisions. Obviously, we had the parole board involved in those sorts of things, but we had a policy judgment prior that said, we will look at whether or not you have rehabilitated, whether you have programmed, whether or not you've received medical care, those sorts of things, and make a decision on when to release you. Fundamentally, that's what we did pre-1984. I'm sorry.
No, go ahead, please.
And after 1984, what Congress did and what we are instructed now from the United States Supreme Court to do is to say, do not consider prison as a way to promote rehabilitation, period, full stop. And so do not consider it in the sense of when we're talking about my hypothetical, I guess not a hypothetical, but my response would be when the court says, please come back and I'm going to consider you for a compassionate release motion if you've been medically compliant and doing what you need to do there and those sorts of things. I think that gives the game away, Your Honor.
But why doesn't that suggest this is the Tapia footnote where the court specifically says we're deciding that you can't order the defendant to have more incarceration because prison might make him better. We specifically don't decide whether you can have the prospect of less incarceration for the same reason. That's the footnote. That's the question they reserve in the Tapia footnote, right? Saying if you get better, I might let you out sooner seems to me to implicate the Tapia footnote, not the Tapia holding.
I mean, our response would be that we think it implicates what's really driving the sentencing in this particular case, and I understand that question was reserved from Tapia, and whether or not.
And it would be an odd world to, we talk about all these compassionate release motions we get, and the main argument that defendants are properly, it seems like to me, making is no, I've been rehabilitated, right? I've done all this stuff in prison that's really great. Let me out. I also have this, extraordinary and compelling reason. But the fundamental argument that they're making is I'm a changed person.
Agreed, Your Honor. And, as someone who practices and does a lot of those things under 3582C1A, absolutely, that is something that you can consider in the framework. The rehabilitation, what has happened while they're in prison.
But why isn't this reference to the 20-month issue exactly that? Right? It's it's a suggestion that ends up not happening, obviously, but it's a suggestion that if you do really well, then I'll have confidence in the safety of the community. So let's try this. That doesn't seem like it's problematic to me under the footnote or under the footnote we're talking about, but also on the very nature that it's about the safety of the community.
Well, Your Honor, I would disagree with that. Our position would be that the whole point of the 3582A analysis is different than 3582C1A with the extraordinary and compelling reasons that must be consistent with the Sentencing Commission policy statement XYZ. However, under 3582A, we're specifically instructed by Congress to not consider prison as a form of rehabilitation or correctional treatment. Right?
So our discussion so far has been almost exclusively about whether there's a Tapia error, and let's just posit that based on JA 191, I think you have a good argument that there is a Tapia error. But then you have a gigantic problem, which is that this is all forfeited. And when I think back to why we have forfeiture rules because the whole idea is that by raising a contemporaneous objection, you might allow the district court to avoid error. And so when I'm thinking about, again, I will just posit that I'm very troubled with the district court says on JA 191 because that just seems to walk right over the Tapia line. But then it also occurs to me that what's supposed to happen then is defense counsel is saying, excuse me, Your Honor, I'd like to remind you about Tapia. So if you are suggesting you're giving my client a longer sentence so he can get rehabilitation, that would violate Tapia. And because what's supposed to happen then is the district court's like, thank you for bringing that to my attention. You're absolutely right. Let me rethink this. Let me clean up my language. And we're never here. So you're just blowing past Alano prong 2. And I really think you have a massive Alano prong 2 problem.
Well, Your Honor, candidly, I agree, and I wasn't obviously there at the sentencing
But
hearing.
you agree you have a massive Alano prong 2 problem?
I agree that we have an issue with forfeiture, candidly, in this case.
Right, but you haven't been talking about prongs 2, 3, or 4 of Alano.
Well, Your Honor, we would argue that we're still subject to plain error review.
Clear or obvious. So it's not enough that this is a Tapia error. It is clear and obvious that this is a Tapia error.
Yes, Your Honor. And we would say in this case that it's clear and obvious because of the numerous instances where the judge, when we review the cases, and we try to review the cases that this court has handed down on Tapia and those sorts of things, normally it's even more reading the tea leaves, is my experience, is that we're trying to say, well, is what they're getting at rehabilitation, is what they're getting at X, Y, and Z. You don't have the district court typically saying,
and then even if you can somehow get over Alano 2, you run smack into Alano 3 and 4. And as I read you on 3, you're basically like, well, they can't show it's harmless. And then I would say, I read Alano again this morning, and Alano says it's not their burden to show it's harmless. It's your burden to show it's harmful. So it's your burden to show that even assuming the district court considered something it shouldn't have considered, that you can establish that it wouldn't have done the same thing anyway.
Yes, Your Honor. I think we have to show that there's a non-speculative basis for concluding that the district court would have imposed a prison sentence of at least 1 day less.
What about the language where the court said essentially that some period of additional incarceration is necessary, at least in part, to provide your client with the medical care and correctional treatment in a manner most effective? That sounds to me like a causal link between the need for rehabilitation and the fact that but for this need, the sentence would have been something different, something less.
I would agree, Your Honor.
Okay, what about Alano prong 4? Because the one thing I know from the Supreme Court is what you cannot do, the one move that is not allowed is to say, which candidly, I think your brief comes close to forfeiting any argument on Alano prong 4, because you're all like, for the reasons we've said, this seriously affects the fairness integrity. And the Supreme Court has said, no, there's literally almost no error that categorically satisfies prong 4 of Alano. The Supreme Court has said, this is a fact-specific, context-specific, there is no such thing as structural error under prong 4 of Alano. So why isn't it a problem that your brief doesn't really brief prong 4 of Alano at all? And second, how can you get over prong 4 of Alano?
Well, Your Honor, we would submit that we get over prong 4 of Alano because it goes to the fairness and integrity of the proceedings because it's so clear, Your Honor, from 3582A and from the structure of the Sentencing Reform Act.
But that sounds like an argument that any Tapia violation satisfies prong 4, and I know from the Supreme Court I'm not allowed to say any Tapia violation satisfies prong 4.
I would agree, Your Honor, that any Tapia violation would not satisfy prong 4. We would submit, Your Honor, that this is a particularly egregious Tapia violation, as we've submitted and we lined out in our brief, given the replete references in the rec.
So why, just help me understand, so the language in Alston, I mean, maybe it was the same district court judge, because it seems to be like very similar, that this sentence will provide the needed treatment of care in the most effective manner possible. It seems like maybe the same judge, I don't actually know that, but extraordinarily similar language. And we say there that that's not a Tapia problem. So help me understand. I mean, I sort of got the same language here as I do in Alston. Why isn't that like enough? if we're on the plain error line, or just like, why doesn't Alston sort of control here?
Yes, sir. May I respond, Judge?
Absolutely.
Judge Richardson, we would submit that in Alston, and as in, I believe also in Lemon, these are passing references and a one-off reference, right? And in our case, what we have here is a series of references and making clear that it truly is all about rehabilitation, not just a recitation of the 3553A factors, where they just tick off, the need to provide the best medical care in the correctional facility and those sorts of things.
Thank you.
Thank you very much.
Thank you, Your Honor.
Chara?
Good morning, and may it please the court. Jacqueline Bashara for the United States. I can start with the quotation at JA 191.
Seems really bad. It seems some additional period of incarceration is necessary for reasons X and Y. And reason Y seems like a very clear Tapia violation.
So if I could push back on that in a few points. First, some period of additional incarceration in context, I agree with, I believe it was Judge Richardson who pointed out, the court, this is of course a claim of procedural error, and when it comes to procedural errors, the court reviews the context of the sentencing transcript as a whole. Here, what the district court was getting at was that I'm not going to give you time served because of these 3553A
So
factors.
additional to what you've already done as opposed to additional what I would otherwise have done?
Yes, correct. Second, we know that reference to the need to protect the public is a perfectly legitimate concern, as you were getting at in my friend's opening argument.
But here the district court specifically distinguishes between protecting the public and some other reason.
Yes, and then my third point was going to jump off of Judge Richardson's point. In my notes I have, this is just like Alston. Just to clarify, I don't think it was the same judge. This was Judge Alston, but Alston was decided before Judge Alston took the bench in the Eastern District of Virginia. So I don't think it was the same judge, but I don't think that affects this court's disposition of this case.
They share sentencing scripts sometimes.
Yeah.
So why
well-
wouldn't we also say that at best that there's, Judge Heidens wants to read 191, I think fairly, to say we're going to have imprisonment time for two reasons, right? To protect and to medicate. But it seems a little odd to read those as truly distinct when the district court has spent the better part of the sentencing hearing describing how those two are inextricably intertwined. And so maybe as a matter of grammar, you read these as X and Y, but reading the transcript as a whole has revealed that this district court believes strongly that X is driven by Y. And so to include two by the use of the word and instead of a slightly different conjunction seems pretty demanding of district court judges' oral pronouncements.
Yes, I agree with that, Your Honor. I mean, I think the overarching gist of both of the hearings that occurred on remand here is that everyone, both sets of counsel and the district court, were concerned about the defendant's ability to sort of conduct himself with other people and the danger that he presented to the public because of his history of noncompliance with medication, right? There were at least 2 documented periods during his incarceration where he was refusing medication that resulted in serious disciplinary infractions. And so, frankly, I am not sure how the district court could have, without procedural error, resentenced Mr. Malaku without considering his need for some kind of medication to resolve his schizophrenic hallucinations and delusions.
Can I just push back a little bit on Alston and the language there, your claim that this is essentially Alston 2? And I'll just read it again. Maybe Judge Richardson did this, but in Alston, the judge said, "This is a sentence sufficient but not greater than necessary. It is a sentence that will promote respect for the law, that will discourage this type of conduct." So there's the rationale for the sentence. And then it seems to me the judge says, also as an added benefit, it provides an opportunity to protect the public and the needed treatment of care in the most effective manner possible. It seems to me that the judge there has decided the sentence on the very appropriate grounds that a judge has to decide the sentence, and then mentions as an afterthought that it provides an opportunity to get medical care. This case is different. The quoted language that I recited to your colleague is, there's a very specific link to the need for additional incarceration for medical care. Don't you think that's different?
I don't. If you look at this court's reasoning, the court said that the district court in Alston, I appreciate, right, we can't say that they use perfectly identical language in sentencing the defendants. I mean, that would be problematic because each sentencing is unique. But what this court reasoned was that
I've
the
read a
district
bunch of
court.
sentencings where district judges seem to say verbatim things in different defendants' cases.
Well, I think this defendant's condition was sufficiently unique.
The more
that Judge
procedural
Alston
requirements
could
we
not-
place upon district court judges, the more likely they are to use a script in an attempt to fix or avoid the procedural problems that we place before them. Fair?
That is fair, Judge Richardson. Just to answer Chief Judge Diaz's question, this court in Alston reasoned that the district court committed no error because he was referencing 3553A2D, which he is expressly instructed to do by the statute. That's exactly what Judge Alston was doing here by saying the need to provide the defendant with medical care and correctional treatment, which, as Judge Richardson noticed, was bound up inescapably with the need to protect the public from the defendant if he fell out of compliance with his medication.
What about the fact that the judge was inclined, before he was dissuaded, to continue the case for almost 2 years in order to ensure treatment? Does that suggest that somehow the judge was unduly fixated on rehabilitation at the expense of the other factors?
I don't think so, Your Honor, because if anything, well, okay, Tapia doesn't concern proposing a continuance. All it concerns itself with is either imposing or lengthening the term of imprisonment. And if anything, the district court was proposing, hey, if you demonstrate, so at the time of the actual resentencing, which was January 2024, Mr. Malaku had only been compliant with his treatment protocol for approximately 8 months. And so the district court was proposing, if you can demonstrate a longer period of compliance, I actually might give you a shorter sentence. I might agree to time served. So that is the opposite of a Tapia error. It's the reserved issue from Tapia. So I don't think that that sort of demonstrates that the statement at JA 191 was implicitly a Tapia error. But in any event, as Judge Heitens was pointing out, this case fails at the second and third and fourth prongs of Alano. My colleague hasn't identified any other case where the court has held that there was a plain Tapia error based on something like this, which is, as Dr. Bloomberg testified and the district court recognized, this is an incurable condition. There is no particular treatment course or program that BOP provides, after which everyone could declare, okay, Mr. Malaku is in remission. So this is not an instance of plain Tapia error where the district court is saying, I'm going to impose this sentence so that you can complete this particular program.
I assume you're aware of what happened in Tapia on remand to the Ninth Circuit, right?
Yes, I
They
am
granted
aware.
relief on a forfeited error. So
Yes,
why
Your
is
Honor.
this error different than that? Because, I mean, we're obviously not bound by maybe we think the Ninth Circuit was wrong, but, we try to avoid creating circuit splits. So could you just walk me through how we would say the fact that we are saying there's no clear, obvious error here is not inconsistent with what happened on remand in Tapia itself, where the Ninth Circuit said there was clear and obvious error? What's the distinction between this case and Tapia in that regard?
Okay, I mean, the factual distinction is that in Tapia, the district court specifically said it was selecting the length of the sentence in order to permit the defendant to complete the 500-hour RDAP
But it just seems like the
program.
district court in Tapia could have said basically the same thing that you say the district court said here, which is like, you're not safe until you've completed drug treatment. So I'm not letting you back into the community until you complete drug treatment, because until you complete drug treatment, you're a danger to the society. And at least the Ninth Circuit didn't buy that sort of reformulation of what the district court had said in Tapia.
But that's not what the district court said in Tapia, and I think to hold otherwise in this case would be inconsistent with this court's decisions in cases like Bennett and Lemon, which held that plain Tapia error, Tapia error was not plain and in any event did not affect the defendant's substantial rights because of the sort of overarching considerations that made clear that the district court would not have imposed the defendant could not meet his burden of showing that there would have been a different result if the district court had not mentioned this rehabilitative purpose.
Does it matter if I don't care whether you put it in prong 3 or prong 4. I noticed that you mentioned to us that he is in a reentry facility, the the defendant here,
He has been transferred to home confinement.
home confinement.
Yes.
Does that bear on 3 and 4? That when we, particularly 4, when we start to sort of say, the circumstances that we find ourselves now, a resentencing, it seems to me is, has some possibility to harm him, maybe, but probably doesn't have an ability to help him either. And so if we sort of like look at prong 4, does that matter at all, or is that too pragmatic?
We haven't made that argument. I guess I don't know of a case offhand where the court has said, basically, we don't think this error is worth correcting because the defendant is essentially already out.
Well, but what prong 4 says in cases like Johnson is like, even if a defendant, I mean, the lingering debate about whether the fourth requirement is a fourth prong or if it's just an all other things equal thing at the end. And say like, even if there's error, even if it's clear and obvious, even if it affected the defendant's substantial rights, the court has discretion to correct. The court is never required to correct the error. And the court has discretion to do so if and only if failing to correct the error will seriously affect the fairness, integrity, or public reputation of judicial proceedings. And I guess what I understand Judge Richardson to be saying is like, the effect of not correcting the error seems likely to be he's in exactly the position he's in right now. So it's not clear that, that's how I would understand the argument. What is your take on that?
Okay, I mean, as a practical matter, if the court were to say, no, we think this requires a resentencing, there is still a little bit of time remaining on the term of imprisonment, which the district court could theoretically reduce. Of course, our position is that the district court would impose the same term of imprisonment because of the seriousness of the offense and the danger to
So
the
given
public.
that where we
And
are,
so all
your
of that-
absolute, his, not your, his, the given where we are right now, this individual's absolute best case scenario is perhaps shortening by some marginal amount a period of home confinement.
Yes, because the other point I would make is that Mr. Malaku never requested less than 3 years of supervised release. I don't know if the court has any other questions.
Thank you very much.
We ask that you affirm. Thank you.
Your Honor, just very briefly, to Judge Richardson's point, my client already got the max available under the current
Oh,
scenario.
yeah, because he's a 20-year max.
Yes,
So
yes,
you're
Your
right.
Honor.
It can't actually hurt him.
Yes, Your Honor. So I wanted to address that real quickly. 2, with regards to home confinement, he is still.
Although maybe, right? I mean, if they, I wonder, I actually don't know what the answer to this is, but if they schedule a resentencing, one could imagine BOP deciding that they need to take him back into custody, and they need to put him on the marshal's bus to get him back, to a facility in order to resentence him, because he's technically a custody inmate. And so I wouldn't be surprised if BOP took him back to custody in order to deliver him to the district court with the district court orders his appearance.
I don't know, Your Honor. Candidly, that would be up to the BOP. They wouldn't tell me even if I wanted to know. He is technically still a BOP inmate at this point, even though he's under home confinement. He's on pre-release custody, which means if he violates or does anything wrong or those sorts of things, it is far more actually intensive than his supervised release conditions. If he violates those, he goes back to prison, do not pass go, those sorts of things. So they're just for purposes of whether or not there could still be some sort of prejudice or harm. And I want to be clear, there's no mootness argument. And I don't take my friend making that argument.
No, I didn't take it either. But when we talk about prong 4, I get it's not moot, right? That's totally fair. But we talk about prong 4 and sort of the fairness and integrity of the system. It feels quite different than if he had 10 more years inside of BOP than what we have today.
Certainly, Your Honor. And, the sentencing happened in 2024, and there was obviously significantly more time while this appeal was pending and those sorts of things. But we recognize the practical reality of it as we're here today. But if the court has no further questions, we would ask that the court reverse and remand.
All right, thank you.
Thank you, Your Honors.
Thank you, Mr. Newton. I want to thank both counsel for their fine arguments this morning. We'll come down and greet you and adjourn until 2:30 this afternoon.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable